Welcome back. While we wait, I hope you all will give me a moment. I've got a few things to say. First one, let's just get this out of the way because this is going to be the totally biased, totally flabbergasted opinion of a woman named Bear with a mic on YouTube. And I'm not a lawyer. I'm just like you, a person who likes to look at true crime, likes to see the legal system in process. And I really enjoy it. And I get really involved in it. So, number one, this process is necessary. Number two, I hope John Pryor's not gloating because it was the judge that gave him the only thing that's going to possibly save his client on one charge for a technical error. And I hope Chad right now has a lump in his throat knowing he lost his house, all his money, and everything he had to pay for her man that couldn't find a clerical error in anything that could have got this tossed, got this done months ago. John Pryor should be ashamed of himself as a defense attorney, number one. Kudos to Judge Boyce for not wanting a mistrial after the fact. As heartbreaking as this situation is, and it is, the fact that the cliff... Oh, I can't finish after.
All right, good afternoon. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from a case, State versus Taylor, 157, Idaho, 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29. Starting then with the counts that I am prepared to rule on. On count one, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim Tylee Ryan was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis, also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion. And count two, the judgment of acquittal motion is denied. Moving next to count three, conspiracy to commit first-degree murder of J.J. Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts again were testified to by witnesses including Zulema Pastenis, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count four, as I mentioned. On count five, This is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenes, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count 1, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count 2, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count 3, Nick Edwards. Count 4, Nicole Heidemann. Count 5, Nick Balance. Count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first-degree murder count, as it relates to J.J. Vallow and the issue the court brought up. So, Ms. Beaty, are you prepared to argue that?
I am, Your Honor. Thank you.
I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third, and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to the date within count 4 or as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from, quote, month, unquote, to, quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of J.J. Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, J.J. Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, a date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And an Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial, or between the information and the jury instructions, only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend, or was left open to the risk of double jeopardy, unquote.
I do have a question about variance,
Yes.
because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course. Thank you, Your Honor. So that would be the state's, and I understand that, I certainly understand the complexities that this course of action presents to the state. But there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here. And I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state, to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, the court, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beaty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point after the state has rested is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now he pled not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on this short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244 that talks about Idaho code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right. Looking back over a rule here, I have an additional question perhaps from Ms. Beaty. I'm looking at Criminal Rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument that you made.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment, they made the allegations, they're stuck with their indictment.
All right, counsel, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling. All right.
Oh, holy crap. Does that mean we stay? Okay. So much to unpack. I don't think that I'm going to need to actually go over originally what I was going to say, because actually Ingrid, Beaty, and Judge Boyce himself actually explained it very well. So, yeah, we're going to stay. Okay, we're staying. Like, are you guys staying with me? Because I'm staying. Like, I'm keeping the stream going until he comes back. Listen, I clearly heard in the language that Judge Boyce was using from the start. All right, there's good things here. All the other counts besides count 4, which is on J.J. Vallow's death, the murder, not the conspiracy, the murder, okay? Count 4 is being decided separately. All the other counts stay. Defense's motion for substantive verdict, asking for an acquittal because the state didn't prove their case. Number 1, Ingrid Beaty, in the last stream, at the end, go back and listen. She laid out that whole case, state point by point how every count was justified. And we just heard Judge Boyce do the same damn thing to make sure he's not overturned. All the other counts are going to the jury. Okay? We can breathe. Chad Daybell should, all likelihood, based on that case, not be a free man. Let's hope that the jury sees that. The jury's not going to know anything that went on about this. They're comfortable somewhere else without the knowledge of all these shenanigans going on. They will just be told, if they cannot, that they are no longer going to deliberate on the murder charge for J.J. Vallow. They won't be told why. They won't be told whatever. They will just be given jury instructions to not deliberate on the murder charge. Yes, he does. And there isn't a person that heard this trial that's not going to hold him accountable, Mandy. No one. That was a little boy in red pajamas buried in his backyard. I understand how hard this is going to be for the victims, but what we're witnessing here, although it's an atrocity that a clerical error can let a man just not face a charge that he rightly should be facing. That's our opinion, yes, from what we heard, from what everybody heard. It's true. But, I heard Larry Woodcock. He does understand that as long as Chad doesn't walk, that's some form of justice. And we're going to have to go with it. Okay? I actually think Ingrid Beaty made a very good case, because I heard in Judge Boyce's language, please help me help you. Tell me where it is that I can focus on to use in my ruling so I don't get overturned. Because I don't think Judge Boyce wants to overturn a murder charge on a child that doesn't deserve to be dead, that he listened to evidence on. He clearly thinks there's enough evidence for the jury to deliberate on all the other charges. I'm sure he thinks there's enough evidence there for JJ, for the murder charge. But he can't even look at it until he decides whether that indictment was amended or not. Fair point. When they changed the date in the indictment in May of this year, original indictment back in February of 21 had the dates correct. When they were given leave of the court to amend other issues in the indictment, That is when the date was changed. We don't know how, because they weren't actually filing for an amendment to count 4 at all. So she makes a valid point, which Pryor helped prove, by the way, by saying that Chad Daybell pled, and all his argument was based on the pleading of the indictment. And let's be clear, he pled on the original indictment, which had the dates were all correct. So he actually helped the state there. And I'm sure the judge heard it. You know, he's a horrible lawyer. I'm sorry. I'm just going to go on. You know, I'm not a lawyer, but he just offends me on so many levels. I'm glad I'm not a lawyer, you know, because then I would know the actual ways that he is actually falling on his face, technically, here. And for him to bring up that somebody else would have found that error eventually, but not mentioning the fact that he never did, should have. Especially with an amendment indictment, he should have went over it with a fine-tooth comb, because everybody knows that the more amendments that happen and the more filings that happen, the more clerical errors there will be. And he could have got he could have got it tossed, but he didn't. He's not earning his pay. And he's just pissed that his acquittal, everything was denied. Every single count was denied except for count 4. And Judge Boyce is just doing what he is responsible to do legally. Make sure there's not going to be an overturn. Make sure there's not going to be a mistrial based on a clerical error. He found it. He understands the issue here. He legally had to bring it forward when he saw it. I know. Just justice for everyone. Carrie, you know, Kay and Larry, they don't deserve not to have their justice, you know. And we can only hope that it goes to the jury. We want the justice that way. Well, several things can happen, right? If they do throw it out, are they going to throw it out with or without prejudice? Are they going to be able to refile on JJ because of the technical error? Will they make Chad Daybell go through another trial on JJ to secure to secure justice for JJ individually? But if they get it on the conspiracy, he's still going away for what he did to JJ. You know, whatever they call it, he's still going away for what if they convict on count 3, he's still going away for what he did to JJ. Yeah, I did, Fish Nerd, and rightly so. Like, I'm surprised my head is even on straight right now. Like, I'm spinning. But as I explained before, this is what I love about the justice system. This is how technical and how fine-tuned it has to be for everyone. Okay? And Ingrid Beaty clearly reminded the judge that it has to be for the victims and their families too. That, you know, we have to protect the defendant and make sure he gets an unbiased trial and that everything's fair. We cannot disregard the victims or their families. They deserve justice too. And to throw this out for a clerical error would be an atrocity, especially when there is some precedent and redetermination that it doesn't have to be, because it's all on the judge's decision. The law states he has to legally address it and get it corrected in some manner going forward. There is no way he's not going to bring it to the jury's attention if the count goes forward. He will. And he will have it addressed. And it will be in their instructions, you know. He's going to dot the I's and cross the T's. Judge Boyce's job is to make sure that everybody gets justice. We all just got busy remembering to breathe. I get it, Rocket Couch. Like, I do. And I was researching, and I want to, you know, I am so impressed. I don't know about you, Mandy, but every ruling that Judge Boyce brought up that he was looking at, she addressed. She addressed it with counter rulings that supported which way he could go. She actually has a clear understanding of the position her judge is in. And you could hear the emotion in her voice and the frustration, because the state, after all of this work, may let down Larry and Kay Woodcock in regards to JJ Fellow. His friends, his family, his loved ones, JJ himself. No one wants that. And Pryor addressed nothing. Did he just not whine, Mandy? I'm so frustrated with him. He really is just like... I know, stomping his feet like a brat. They can't amend it. No, they don't want to amend it. Let's be clear. Ingrid Beaty just said, technically, if you want to get technical about the date, let's get technical about the fact that the court never gave us permission to amend count 4. Therefore, count 4 isn't even amended. So the wrong date doesn't exist. Like, it's almost as if the document has been printed with all the other parts in there, and somehow or other this got changed. But they were only allowed to amend the indictment in certain areas based on the court's permission. And that was all just laid out by Ingrid Beaty and the process. Okay. Count 4 was not part of the approval by the court, which means technically in the record, as it exists in a whole, Ingrid Beaty is correct. The date goes to the original indictment. That's what Chad Daybell pled to. Chad Daybell's rights are not violated at all because the court never gave the state permission to amend count 4. Pryor's argument that they can't amend was ridiculous. They're not amending. They're saying it's not an issue. Ingrid Beaty clearly went forward with everything to state it's really not an issue, Judge, because didn't you say we needed your permission to amend? And didn't you say this is the only areas we could amend? So if a typist made a clerical error when she copied stuff over, it doesn't matter because the only thing of technically in the record as amended is the ones that you told us we could. And it wasn't count 4. And I found that brilliant. I mean, brilliant. At least I hope I'm correct. Did I hear that correct? I mean, do you guys Mandy, help me here. Am I just spinning my wheels? I mean, that's what I heard. That's how I interpreted it. What did you guys hear? I really want to know what you heard. I know, Mandy. We can all, like, you know, we're gonna all have to go purge later. Right, Racket Couch? That's kind of what I was hearing, right? That's what she said, right, Liz? And you know what? I'd already looked that up. That is the process. That's the research I did on break. And for those of you that were messaging me that I didn't get back to, I apologize. I can only focus on something this serious with 100% of me. I really needed to research every single law that he said under Idaho statute. I went and looked up everything Judge Boyce said. Then I looked up the possibilities of what they had said prior to what they left. Ingrid Beaty went through all of the evidence for every other count. Exactly, Mandy. So you're hearing what I'm hearing, right? She's saying, well, if you want to get technical, here's the technical. It's not even amended. Sit down, Pryor. Sit down. It's not amended. Exactly. And I hope she gave Judge Boyce enough to make a conscionable ruling and allow it to go to the jury where it needs to be. Because Chad Daybell needs to be held accountable. Especially after testimony we heard the last 2 days, which was quite damning. Very damning. He didn't, did he? Except for outrage that he says that they want to amend everything as if they were bringing new evidence or a new witness or something, and that's not the case. Pryor's arguing on the point of, yes, he's correct. Once you rest your case, you're not allowed to reopen it. They're not asking to reopen it. They're asking the judge to look fairly at the fact that count 4 was not amended and a typo doesn't matter. It is dumb, Mandy, yes. And if it was about that particular date, then yes. But like they're amending a whole huge argument. And here's the thing. If you only had permission to amend one section of that contract and the date wasn't in that section, then is it actually amended, the date? Because in a court, they needed permission to amend every section. That's right. It wouldn't change. It wouldn't change the original parts of the contract that weren't approved for amendment. I will agree that everything the court approved to go forward for amendment stands as the amended part. And if the bad date was in there, they would be sunk. You know what I mean? Exactly, Mandy. You see, Mandy and I deal with contracts, insurance contracts. We deal with business. Juju, you know what I'm talking about. Black and white. To me, like, this is what I love about law. This is what, like, this is why it became my hobby after coming from the business world, because it just made perfect sense to me, all of it. And also the justice part of it and watching the system working. So at the same time that I'm crying for the family, and I'll be honest, people, I got off this stream quick because I cried. I cried at the atrocity of the fact that this could get tossed out over something so small after all the work. And I didn't just cry for JJ or for Larry and Kay Woodcock. I cried for all those law enforcement officers for years of work in investigation. For Detective Hermosillo, who dedicated his life day in and day out to find those children, just to be faced with the atrocity of those text messages between Chad and Lori. Who wouldn't be? Who would not be offended? So I got my frustration out and I cried. And then I searched and I researched and I became more comfortable with the system. As hard as this is to go through right now, this is why our system works. Yeah, I do that often, Mark. I'm an emotional person. When I get frustrated or mad, I may spring a leak. I may. But then I get calm, and I get serious, and I get a bit brutal. And I have no choice but to look at this in the black and white. Sarah, you okay? I want everybody to be okay. It's hard. As hard as it is to wait and to think that there won't be justice, there still will be. Remember, JJ's other count is going to the jury. JJ's name is still in that part of the indictment. JJ's family will still be in court to watch Chad Daybell face the jury. Let's hope the jury does the right thing. What we believe is the right thing anyway. Biased as it sounds. That evidence this week. I don't know what Pryor is going to pull out of his hat for his part, but based on what I've seen today, I would say, oh well. It's no what they're going to do. They're going to try to turn Chad into the victim. He's being persecuted unrelentlessly after they heard all of that. I don't think so. Did you notice Pryor won't address the fact of Tammy Daybell's murder? He knows they proved that hands down. Oh, Sarah, you live in Redsburg? Wow. Well, Sarah, we're here for you, all of us. It's going to be emotional out there, Sarah. I saw the video of Larry Woodcock talking to Nate Eaton, and he's upset, and rightly so. But he'll be back in that courtroom for this. You'll see. He wants to see it through. And he doesn't understand how anybody could take the life of a child like that, and that every child needs to be vindicated. And I hear him. I'm sure you all do. Well, take care of yourself, Sarah. It's going to be an emotional day. Yeah, I can't. I know he's doing his job, Sarah, but I feel for you. I do, because I don't really have a lot of respect for him right now. I really don't. That's why I thought it was important that everybody make note. John Pryor didn't find this error to get this tossed. I don't even know if he's capable of it, to tell you the truth. You did? You went to college with some of his children? Well, then this must hit pretty close to home. And I feel for you, the disruption in your community, all about. If you ever want to talk about that, you let us know. I wonder how the community is responding to this trial in Rexburg, where Chad lived prior, in Utah, where Tammy was, even in Arizona, where the Valos live, with the upcoming trial for Lori. We've all been on this trial for so long, and we want it to come to an end with justice. I don't think Chad is a very popular figure either, Mark. I really don't. And but then again, he comes from a tight-knit community that has some very different beliefs, and they accepted him in that community somewhat, even after he just basically walked away from his wife so quickly to marry Lori. He didn't get kicked from the church that I heard, and yet I know others have been kicked for less. Exactly. We want justice for those babies and Tammy. Man, Judge Boyce is in such a tight spot right now, and he's being very careful. And don't forget that whatever he decides, he needs to put down in black and white the legal precedents for it, so that things don't easily get appealed or overturned. And, you know, that's going to take a little bit of time, and I'm sure he's got everybody jumping through hoops trying to help him. Sarah, I would love to see an article or anything on that. You believe that he was excommunicated? Because I think he should have, just based on how he treated his wife. Just the common knowledge of the affair a year before she left. That he actually had a sacred ceremony with another woman in their temple while he was married is an atrocity against their beliefs, is it not? Like, I thought so. Thank you, Sarah. Like, I don't want to put you on the spot. Whatever you're comfortable doing. But I would appreciate the information if you do get it. Only just to answer my own questions. And if you don't want it made public, I won't. Whatever you do, I want you to be comfortable with it. I know this is hard because you're from that area. It's a lot to deal with, especially to hear your beliefs, your religious beliefs put on trial here, because that did happen a bit unfairly to LDS. Not, you know, I don't know that much about it, but I do know Chad's beliefs were not exactly LDS beliefs 100%, and I don't want that to spill over unfairly to those beliefs of the LDS Church. They don't condone what happened here. You know, there's nothing in the teachings that say that what Chad Daybell did was appropriate, or what Chad Daybell. I still need to say allegedly, don't I? Because it hasn't come back from the jury yet. So his charges, his accusations that have been made allegedly. But he didn't allegedly have an affair. He seems pretty proud of that. and he married her right away. So that should be enough. All of the testimony we heard today, him talking about the children in such a manner. Heartbreaking. So, well, not to make any pressure, but if anybody has anything to say, I'll give you the link while we spare some time, because this is your stream too. Those of you that watch it with me, that have the same hobby as I. We're not lawyers. We're not paralegals. We're not in the court system. We're watching it because we like true crime. We have a fascination with legal, like I do, or you want to see the justice system at work, or or you come from the area like Sarah, or you just know of the case and you want to see it resolved. Well, this is for all of us, not just me. I thought so, Liz. It didn't really have anything to do with the affair, right? It was because he claimed to be a prophet. That's what I thought. Do you have anything to support that? Because I think later I might be doing a stream on that when the trial is over. If anyone deserves a video, and I hate making video, but when I feel strongly about something, I do it. Chad Daybell's claiming that he is the exalted one definitely deserves a video, especially if he's convicted of murder, conspiracy, and insurance fraud. That will definitely appear on a What the F Legal for sure. I know. What they did was horrific, and I'm sure that it's horrible for members of your church to even think about it. That's how they're representing it. Thankfully, some of their beliefs were crazy enough that they're not even associated with LDS. Pryor did do one thing. He asked if these were LDS beliefs a lot, but when he picked on the women, not Chad. Now he wants his defense to be, this was just Chad's religious beliefs. You can't try him for his religious beliefs. Was there, Sarah? If it involved children, I probably avoided it. To be honest, I have difficulty with the cases with children. I wonder, did anybody get their bingo card full? Oh, did I not? Oh, I probably didn't. Let me just make sure that I put it up there. I might not have. Yeah, I was kind of rushing to get this up. There we go. I wonder, you guys don't forget to send me your bingo cards if you win. If you get one. This is definitely not a square, though. Coming out of left field with a clerical error to just put the whole trial at jeopardy. Right before the state rests their case. I didn't see that coming. Oh, Ruby Frank. Oh, I do know of this case. It's horrible. Like that. There's no way to avoid that case. It was everywhere. That has to be so upsetting. They were horrible. The condition of those children. Oh my God. I feel for you, Sarah. Sarah, Liz says, if you Google, was Chad excommunicated from the LDS Church? They don't call it excommunication anymore. That Julie Rowe was kicked out too. And yes, based on those beliefs of, the multiple, not just the multiple lives, but the prophecy. It did involve Ruby's 2 children, yes. Horrible. Technically, it is a square, says Rocket Couch. That's the motion to dismiss clams. But I definitely don't expect something this big to check it off. Well, you can, because like Pryor did, as he was supposed to, he did motion to dismiss, but he wanted an acquittal based on lack of evidence. And he just opened the door for all the evidence to be read out again. For us, we got a nice little recap. Yeah. Thank you, Liz. I had not Googled it yet. It just had come across my mind, you know. I had heard Julie Rowe was that there was a lot of contention within the community and within the church itself and the higher ups in regards to what they were putting out there as teachings and stuff. And they weren't all behind these castings and these light and dark spirit thing. No, they weren't behind any of this. Well, Chad Daybell got a lot of this from Julie Rowe. When he started his book writing started to change. I'm hoping they're going late and I'm not just sitting here like waiting, but as you can see, his stream is still up. If he decides to quit and come back in the morning, I do believe he would come in and have the courtesy to tell us, or at least have the clerk tell us, so he cut the stream. But, you know, that stream is still up live. Yes, Mandy, we do. And Mandy, please join me for the stream or the video in regards to Chad Daybell in this at the end, and how this split from LDS is happening and how this prophet went awry. Yeah, we need to research that Julie Rowe and find out what else is going on with her for sure. Because that is, she talks like a cult. Yes, he was. He actually knows the correct procedure. He knows he has to address it because he knows he has a legal right, a legal responsibility rather, to not let it go forward with the date the way that it is. So he has to put something on the books on whether that date gets ignored because it's not actually a true amendment to the indictment, or if the count gets tossed because the date is incorrect, the amendment went forward and there is false claims there, so the evidence can't be applied to those dates, and that's the issue, Mark. The evidence they presented was for July. The date, the evidence they presented was for September, and the date is July. If they don't match, it doesn't exist. You can't apply the evidence to the indictment, it's out. Therefore, the count is gone. And he's back. Mark, you worked the charm.
Thank you. Please be seated. All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the courts considered those arguments, and at this time we'll make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on Criminal Rule 29, which is for a judgment of acquittal. I already indicated the standard in the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court having considered the arguments of the state and the defense, I'm going to rule as follows as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state, by motion in November of 2023, sought to amend the indictment, and the court went back and reviewed that motion to amend the indictment, and specifically leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023 granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of J.J. Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years, that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving J.J. Vallow as a victim, and he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of J.J. Vallow in this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court, having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I've also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It was not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beaty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All right.
Oh my, I'm going to hang for a few minutes. That was exciting. I'm sure he just cut off. He can't wait to start his weekend. We have tomorrow off from trial. But the good news is, this trial on Monday. There is trial on Monday with all counts reinstated. Mandy, there's hope. There's hope for the justice system. I hope that Larry Woodcock is crying tears of joy right now that he didn't get tossed. I'm sorry that the family had to go through that, but this is justice. And Pryor has a couple of days to lick his wounds and get his damn case in order for Monday. Well, he's going to have to really pull it out. No, Mark, I'm not crying because I'm just feeling like a little, oh, booyah. That's exactly it. If I have to explain how I'm feeling right now, that's the word. Booyah. Like, that was justice. The wheels of justice in motion. You know, Beaty and I both were so pissed at Judge Boyce in the beginning, but I have grown very fond of his dedication to the dotting the I's and crossing the T's. He is relentless with the don't make it my problem issue. And he found a problem that was going to be his issue. And it was going to be bad for him. And it got solved. It got solved. And he's even now going to take the time over the weekend to figure out the best way so that it's not too prejudicial to either party, whether he uses jury instruction or just a simple order to correct the file. But, and you know what? I'm feeling rather good that what I heard and interpreted is exactly what I heard, because it made perfect sense to me. And that's what I love about the legal system. As crazy and intricate and spiderwebby that it is, when it comes down to it, the issues are all black and white. And it's all a matter of just proving them with the right words. I'm telling you, inadvertent was the key word that Judge Boyce said in his ruling today. An inadvertent clerical error to a part of an amended indictment that isn't technically amended. Inadvertent, no one's fault, not prejudicial to anyone. Interpreted, I don't know what I said, Mandy. I probably said something really messed up because, you know, my tongue will like practically tie itself in its own knot. What I heard is what I heard is what I meant. Probably, Mandy. I don't know. But I'm not trying to like be a lawyer here at all. I'm just a layperson that listens to it and just makes a black and white judgment about what I hear. And I love it. And I think we all need a nap, Shill. Thank you all. I won't be joining you tomorrow. I might do a true crime stream on some other cases if you want it. I don't know. Let's see. I might just be too exhausted from holding my breath so long. I don't know how I'm going to feel. But hey, victory whiskey, it's not a victory yet. When the jury comes back with that guilty, that's a victory. That's a victory. Yeah, I'm going to miss you too. I'm going to miss all of you tomorrow. I might do true crime in the evening. I'm not sure. I've been trying to take the weekends off so I don't like press too much, except for Sunday. I know I'm going to be here Sunday. And I know I'm going to be here Monday morning, and I hope all of you will too. And I can't promise you things will be perfect because I never am. Like, I may forget the banner. I may talk over the judge because I forget to mute. It is my intention not to, though. I may tell you stuff you don't even want to hear. I may make inappropriate jokes and the unintended innuendo. And I misspeak a lot as far as pronunciation of certain words because I get so excited, my brain goes faster than my mouth can keep up, if you can believe that, because I am quite the fast talker and a long talker, But I'll be genuine. I'll be just like you, just like every one of you in that chat watching this trial. The same. I have no more information than you do. Whoa, we're halfway there. Are you singing in chat to get a bingo square? Rocket couch. Sorry, not sorry is right. Mandy says, I hope Larry and Kay are okay. I can't imagine how stressful the last few hours. Larry was quite upset. Nate Eaton talked with Larry outside of the courthouse, and there is a clip of that. I think I did put it in the chat early on in the stream. I do have my ears. Yes. I am just a little bit different than you guys because I have cat ears. I doubt you're all sitting there with cat ears. I don't know if you guys know that the cat ears started as a joke against another YouTuber. He was giving me some grief and blocked me. Started my trial because I called him out for misinformation. I think Rocket Couch knows who I'm talking about. I wonder if any of you know that story. But yeah, I just think I look better in the cat ears than him. And somebody had said, nobody can make cat ears look serious. And I was like, I can. There they are. Yes, then they were stolen, Mark, and I got them back. Listen, let's not bring that up. Juju said she was sorry. Listen, we don't want to go there. She's had a stressful day. Yeah, she's had a stressful day. We don't want to start. Like, take my hand and we'll make it. I swear, you got it, Mandy. And damn, does a Jersey girl love some Bon Jovi? I do. Please sing away. If that's the song you guys want to sing, sing it, sing it, sing it. Because, lamb, there's nothing wrong with a little Bon Jovi, especially at the end of a stressful week. That was a ride. Would you agree, people? That was one hell of a ride. The last couple of hours. The last couple of days' testimony was emotional. Oh my, you're going to have a storm? Oh ho, he's a dingus. Oh ho. Oh, you mean, yes, we're talking about, okay, I'm going to say it. Not that he deserves his name to be said on any of my streams, but the person responsible for this bear wearing cat ears every day since I started my channel is Deaf Noodles. Shh. Yes. I hope Kobe is doing okay too. I know, Juju, you don't deserve any more abuse. You don't about it. You came clean. We've gone through our friendship therapy too. It's been very stormy and very windy and rainy here. Well, anyway, I'm running out of things to say. Let's not rehash the stolen goods. Let's not. I got them back. They look great, right? I tried a bunch of other ones, puppy ears and antennas and all kinds of stuff. It didn't work. Oh, he is a dingness. Mandy, are you talking about John Pryor? Yes, I did some research on him, and boy, am I not happy. And I do see that people are going to try to join because I did put the link out, but I am ending, so I'm not going to bring anybody up. Sorry, but maybe on break on Monday. I just want to be clear, nothing personal to anybody. I'm just like, I'm wrapping up. It wouldn't be fair. Yeah. Juju is being very nice, like, as all of you all. I thank you for being here. I know it's been emotional. I know it was quite a ride, but I'm very happy you all joined me for a part 2 stream, to make sure we got that all documented and to let me vent afterwards a little bit. I appreciate that, because now everybody else in my real life, in my personal life, doesn't have to hear it. I don't have to call Mandy and carry on for 3 hours because I've kind of got a little bit of it out. But Mandy, I'm here for you. I'm here for you if you need to. You know it. And just like most of you that are in the Discord, you want to talk about it, hit me up. I will be here Monday morning. I'm thinking about a stream Friday night, but we'll see. Mark, I'm going to put this up only because it's a worthy comment, a very worthy comment. I feel a little sorry for Pryor. He's fighting a losing battle and really working with not much. It would be hard for him to do a good job in any way. It is, and yet I actually do expect him to do it without whining. And if there's an amendment to anything, it needs to be gone over with a fine-tooth comb. That's just legal 101. And I know he whines about time. It's not my fault he doesn't get a good paralegal that can do that for him, because they would have caught it. They would have caught it, and they could have really made a fuss and had the whole amended indictment pulled, which would have been an even bigger issue for the case, because there was additional evidence in there that went against Chad Daybell that didn't need to be, if you get my drift. But I do feel sorry for him occasionally, Mark, and then I remember that he's brought this on himself. Remember, we're talking about the man who filed a motion to get off the case and then told the judge during the hearing for that motion he didn't want to leave the case. And that Chad didn't want him to leave the case. But he argued that he had to leave the case because it wasn't fair to Chad and there was no money and this, that, and the other thing. Any excuse he could come up with, and then said he wanted to stay. Well, anyway, now my phone is going off like a rocket, so I guess I will see you all. on Monday if I don't see you Sunday at our casual stream or Friday for true crime, if I do it, you know. But thank you all for being here. Have you all ever listened to Claire at 2 times speed? It makes her like an honorary mouse. Does it? Does it really? I'll bet you it must be kind of scary. Oh, a criminal mind is all I've ever known. They've tried to reform me, but I'm made of cold stone. Good one there. Cross it off on your bingo cards. Rocket. Who's Rocket? Rocket, leave Claire's phone alone. Oh, I don't know. I don't know. But anyway, thank you all. I can't tell you how much it means to me that you're here every day. It would be impossible to be out here talking to myself and not have the company. I would be miserable. Yeah. Like maybe like Rocket, like Couch, but a dumb. Yeah, don't start no rumors, people. Yeah. But God, if it was Couch, I would pick it up. He's a great person. You see the work he did on that bingo card? He's amazing. He's a good friend. He's good people. Just like most of you are here in the chat. And I am so glad you're all here with me every day. And I've said that about 20 times already. So I'm going to just, before I make an idiot of myself, I am just going to end the stream. Grateful that we got to watch justice really working today behind the scenes, how it does on really complicated issues that are going to hurt somebody one way or the other, trying to be fair to everybody, as it should be. So I will see you all for this trial Monday morning, 10:20 for me, 8:30 in Idaho. And get ready, buckle up, buttercups, because we got to listen to Pryor relentlessly from Monday forward till he's done. But there's hope at the end of the tunnel, because then prosecution gets to come back with rebuttal. And that should be fun. Because the one thing that Lindsey Blake is very good at is rebuttal, as you know. All right. See you all later. Bye.